Most business owners spend June focused entirely on tax. But the contracts you don't have in place right now, they're the legal problems that show up in the new financial year, and they're significantly more expensive to fix after the fact. I'm Sahil Bhandula, senior lawyer here at Lawpath, and in this video, I'm walking you through the 4 most important contracts every business should have in place before June the 30th. What they are, the key clauses you need to consider, and how to create them today using Lawpath. Let's get into it. First, employment contracts. If you have employees and their contracts haven't been reviewed since you hired them, that is a problem. Businesses evolve, roles change, legislation changes. An employment contract written 3 years ago may not reflect the actual job someone is doing today, and that gap is a liability. End of financial year is the right time to review every employment agreement before the new financial year begins. Here are the key clauses to check in your employment contracts. Remuneration. Does it actually reflect the current salary or wage? If there's been a pay increase that was never documented in writing, that definitely needs to be fixed. Second, roles and responsibilities. If someone's role has expanded or changed, the contract needs to reflect that. Third, termination provisions. Notice periods need to comply with the national employment standards. If your contract has a shorter notice period than the NES requires, the NES wins, but the discrepancy still creates confusion. Confidentiality. Every employment contract should include a clause protecting your business's confidential information, client data, and intellectual property. And if you don't have written contracts for some of your team, fix that up before the 1st of July. A verbal agreement is not protection. Second, contractor agreements. This is the one that catches businesses out most often. If you're engaging someone as a contractor or a freelancer, maybe a consultant, a specialist that you maybe bring in regularly, you need a written agreement that clearly establishes the nature of that relationship. Without one, you're exposed to sham contracting claims, superannuation liability, and fair work disputes. Here are the key clauses you need to consider in a contractor agreement. Firstly, the scope of work, exactly what they're being engaged to do. A vague scope leads to disputes. Second, payment terms. What's their rate? Is there an invoicing schedule? What happens if the deliverables aren't met? Next, the independent contractor declaration. We need to explicitly state that this is not an employment relationship, that they operate independently, and that they are responsible for their own tax and super obligations. Intellectual property ownership. Any work product created during the engagement should vest in your business. Without this clause, the contractor may continue to own the IP by default. Termination clause. How either party can end the arrangement and with how much notice. If you have contractors working for you right now without a written agreement, this is the first document you need. Third, the client services agreement. If you deliver a service to clients, any service, you need a written agreement that governs that relationship. A handshake deal or a brief email exchange is not quite a contract. And when a client dispute arises, and at some point one will, the question is always, what did you agree to in writing? Here are the key clauses that you need in a client services agreement. Firstly, the scope of services. What will you deliver? And equally importantly, what will you not? Scope creep is the most common source of client disputes. Payment terms. Your fee, your invoicing schedule, what happens when invoices aren't paid, and whether you charge interest on any overdue amounts. Thirdly, limitation of liability. This clause limits your financial exposure if something goes wrong. Without it, your liability is uncapped, and for professional service businesses, this is really a non-negotiable. Dispute resolution. How disagreements will be handled before either party goes to court. You want to have mediation clauses that save both parties time and money. And termination. Under what conditions either party can exit the agreement, and what happens to outstanding fees when they do. Next, your privacy policy and website terms of use. These are 2 documents that most small businesses either don't have or copy-pasted from somewhere years ago and haven't touched since. Under the Australian privacy principles, if your business collects personal information, and almost every business does, you are legally required to have a privacy policy that clearly explains what you collect, why you collect it, how you store it, and protect it. If you have a website, you also need terms of use, governing how people can interact with your content, limiting your liability for the information that you publish, and setting out your intellectual property rights. These are not optional documents. And with privacy law reform continuing to move in Australia, having outdated or non-compliant policies going into financial year 2027 is a risk that you don't quite need. Now, how do you actually get all of this done before the 30th of June? Let me show you exactly how to do it using Lawpath. Step 1. Head to lawpath.com.au and create a free account. It takes 2 minutes. You'll land on your Lawpath dashboard where you can access all your legal documents in one place. Step 2, go to the documents section and search for the contract that you need. You'll find lawyer drafted templates for all 4 documents we've covered today: employment contracts, contractor agreements, client service agreements, privacy policies, and website terms. Every template is drafted by an Australian lawyer and built to comply with Australian law. These are not generic overseas templates. They are written specifically for businesses operating in Australia. Step 3, answer the guided questions. Lawpath walks you through the document step by step. You'll fill in your business details, the specific terms of the arrangement, whether it's payment or scope or notice periods, and the platform builds the document around your answers in real time. No legal knowledge required. The questions are plain English and take you through everything that matters. Step 4, review, customize, and finalize. Once the document is generated, you can review every clause, make edits, and tailor it to your specific situation. If at any point you're unsure about a clause or want a lawyer to review it before you send it, Lawpath's legal team is available to do exactly that and directly through the platform. And step 5, send for e-signature through the Lawpath platform. Once you're happy with the document, you can send it for electronic signature straight from Lawpath. No printing, no scanning, no back and forth over email. The signed document is stored securely in your account, so you always have a copy on hand. Most of these documents take under 30 minutes to complete from start to signed. The legal protection, though, that they give your business lasts for years. None of these are complicated, but all of them do matter. The link to get started with Lawpath is in the description below. You can have the first document drafted today.